Hello viewers, welcome to another session with the Law Basket. In today's lesson, we will be discussing the Sierra Leone Customary Law and its features. The objectives of today's lesson is to know the place of customary law in our legal system, the customary law of Sierra Leone, how customary law operates, and the features of customary law. To start with the place of customary law in our legal system, one should note that all legal systems around the world are either borrowed or developed by precedents. For our country, Sierra Leone, we have a legal system that is dualist in nature. We have the general law and customary law. For the general law, there are laws that are in force in Sierra Leone other than the customary law. Whilst for the customary law, there are rules of law which by custom are applicable in a particular community in Sierra Leone. For that, we can say customary law is part of our legal system. Next, we go to the customary law of Sierra Leone. For our country, the most appropriate definition for customary law, it can be found in the interpretation section of the Local Court Act of 2011, and it defines customary law as any rule other than a rule of general law having force in any chiefdom of the provinces, whereby rights and correlative duties are acquired or imposed in conformity with natural justice and equity, and not incompatible either directly or indirectly with any enactment applying to the provinces, and includes any amendment of customary law made in accordance with this provision. As to the definition, we can realize that customary laws are only applicable to people living in the provinces and not in the western areas. And also, if there is any amendment being made in accordance with the Local Court Act of 2011, no customary law must be inconsistent with such law. Just as any other law, the customary law covers different areas from marriages, divorce, land, succession and inheritance, chieftaincy, adultery, and many more. And we should also note that in our country we have different ethnic groups, and amongst these ethnic groups we have various customary laws existing between them, and for that our customary law within the country varies from one ethnicity to another. So we go to the next subtopic, which is how customary law operates. Before the establishment of local courts in our country, the chiefs and sub-chiefs used to be the custodians of customary law. And in the case of any breach, an individual will be fined to pay in agricultural produce or in any other goods that is worthy. But since the establishment of our local courts in 1963, 1965, 2001 and 2011 respectively, we can see that the local courts are the courts regulating customary laws through the local court chairman, and local courts do exist in every district across the country. In its operation, customary law only governs people residing in the provinces and in any area where such laws has been accepted. And also, customary law in one chiefdom is not the same in another, because we have different ethnic groups. Though in some cases they might be similar, but they will not be completely the same. And customary law do not operate in the western area. And all indigents in a particular chiefdom, whether you are residing there permanently or not, such person must conform to the customary law and should not act inconsistently with that law. And in conforming to the customary law, it should not be inconsistent with the general law. And in the case of any breach of customary law, such matter must be heard in the local court and presided over by a local court chairman. This is the mode at which or in which the local courts do operate in Sierra Leone. One key thing to note is that it is not in operation in the western area, Freetown to be specific. So next, we go to the features of customary law. Some of the features of customary law are as follows. One, it is generally unwritten, meaning there is no particular statute or certain set of regulations that state that these are the customary laws of Sierra Leone. Hence, it is being passed on from generation to generation, and there is no codified laws in Sierra Leone that one can refer to as the customary law of Sierra Leone. And secondly, it is flexible. Hence, they are unwritten, then they can be changed at any point in time. And in the dispensation of justice using the customary law, the local court chairman can use his wisdom to do so, and he can change them at any time because it is flexible. It needs not to go through any regulation like laws that have been passed in parliament. It needs no particular place that they will rectify such laws. And also, it is adaptable to socio-economic change, meaning hence society is developing and gradually we are going to different aspects. Customary law as well is moving and is adaptable to such socio-economic development. For example, prior to now, chiefs used to fine people who violate customary laws to pay in agricultural produce, but for now they are finding people in monetary value, meaning customary law is now being adapted or now being adaptable to socio-economic change. And fourthly, customary law is discriminatory in nature, meaning some laws that are found in some customs, they are discriminatory against women. For example, most ethnicity or most ethnic group don't allow women to acquire chieftaincy, and chieftaincy is exclusively being reserved for men. And as well, women are not allowed to inherit their father's property. So by that, one can say customary laws are discriminatory in nature. These are some of the features of customary law, and this is the end part of our lesson for today. Thank you for watching, and don't forget to subscribe and hit the notification bell. See you in our next session.